Commission resumes. Mr. Tip.
Thank you, Chair. Chair, in the time available, I propose to deal with a limited number of topics and to do so as rapidly as I can, bearing in mind that there are a number of parties who still have to address the Commission. The topics that I will deal with are, first of all, an examination of the 5 employees who were killed in the course of the 12th, 13th and 14th of August 2012 by the strikers. The Commission has already received some detail concerning those. I am back on the air. Thank you, Chair. Yes. I was just in the process of saying that there is additional material to which the Commission should, with respect, have regard. That is to be found in the post-mortem material. And then we will also address an aspect concerning particularly Mr. Twala that should be highlighted. I am going to make submissions in respect of all 5 of these gentlemen. Mr. Fundi, of course, as you know, formerly I act for Mrs. Fundi. Mr. Mabalani, Mr. Mabebe, Mr. Langa. I've discussed this with my learned colleague, Mr. Ampele, and he's very satisfied that I should do this. In respect to Mr. Twala, we don't have a formal instruction, but we have given assistance to the family inter alia in the presentation. And Mr. Twala was, of course, a NIM official. So that is an aspect that we think is important to complete. Then the second topic will be in the field of labour relations, collective bargaining, and there I shall seek to highlight some particularly important features of the labour relations environment, particularly in respect of the nature of collective bargaining and how it is to be respected. And the purpose of that will again be essentially to seek to be of assistance to the Commission in that it will be generally submitted that the events that the Commission has been concerned with over the past 2.25 years need to be inter alia closely connected with the proper appreciation of what the labour relations environment implies for those events. Those will be the principal topics, perhaps. And then, thirdly, we will deal with aspects of the events of 10 and 11 August 2012. Chair, I will try to be brief there. We have various references to the transcript. I had thought to read through them, but I will instead just summarize what the submissions are and give you the references to look at more fully. There will be 1 or 2 comments concerning submissions made by my learned friend Mr. Baum in relation to Lonman Security and its operation and what it could and could not do, but those will be highlights. In all of these topics, Chair, we will very much bear in mind that we have had the opportunity to file written submissions. It was a hard-pressed job. It turned out to be enormous, and the deadline came forward inexorably. But we believe, nevertheless, that we have captured at least the essence of the topics that particularly affect NUM. And
I wanted to say it, I was going to say at the end, I may as well say it now, that not only you, but your colleagues as well, that you have given us an enormous amount of assistance in the written heads supplied, references to the evidence, highlighting important aspects. So it is a formidable task. It's going to be a formidable task to write the report. I see it as a big mountain in front of us, which we have to climb, but we're substantially assisted by the heads that we've got from all the parties. And the topics that you deal with in fair detail, full and comprehensive, actually, heads. And they also will be of great assistance to us. And I think it's appropriate not to express our gratitude not only to you, but of course to your learned friends appearing for the other parties, the evidence leaders, and the Human Rights Commission, and LRC as well.
well, thank you, Chair. And those remarks fortify me in the view that I can indeed deal with the topics that I wish to highlight fairly swiftly. May I just add, arising out of that and perhaps echoing a little bit of the debate that we had yesterday concerning the questions that Mr. Semenya might address in the supplementary note if he wished to, and to make this general offer, and I'm again confident that all my colleagues would share my view, and that is if in the course of the deliberations over the next many months that the Commission must now undertake, certain topics appear not to have been fully addressed to the satisfaction of the Commission, a word to us, and we will very, very gladly give any further assistance that we can.
If we do that, of course, we'll ensure that whatever assistance we get would be in written form.
Yes.
Will be circulated to all the parties so they can comment on it as well.
Oh,
yeah,
quite so.
That is a generous offer, and before it's withdrawn, I hasten to accept it.
It's cast in stone, and of course, this would, Chair, this would be done on an absolutely transparent basis. Yes.
I wouldn't expect anything else. I think I'd have to set a deadline, and that would have to be. But of course, the answer is the initiative would come from us. There are two aspects. So far as the initiative comes from us, we don't have to set a deadline because we will be masters as well of that. But if parties wish to get extra thoughts or extra points they feel we haven't perhaps understood it, I believe there's a suggestion. I don't understand McCann's case properly. Well, if I will see when I get a note on that whether that's correct. But anyway, the fact of the matter is, if there are points that people feel we don't understand properly, or we might overlook, haven't been dealt with properly in the argument, they're obviously free, again on this transparent basis you've referred to give us extra notes on the point. But there, I'm afraid, I think I'm going to set a deadline, which will be the end of January.
Yes, that's appreciated. Certainly, when I raised this proposal, I had in mind that we would react only to requests from the Commission, and that it shouldn't become another open season for further.
I understand that, but it would be rather awkward if there's a big point somewhere that's eluded us all, and it suddenly becomes clear to one of the parties, and it might well make all the difference, or significant difference on a particular part of the matter. It would be rather embarrassing if they're not allowed to tell us, and that we blunder on, produce a report overlooking this point if there is such a point. So that's why we have to have the two aspects.
Yes. Quite so. Thank you, Chair. Then if I may turn to the first area that we wish to address, namely the circumstances of the killings of the five gentlemen I've referred to. Why this is important to complete, Chair, is that, as we all know, it's been in the nature of the investigation of the Commission that a good deal of scrutiny has been given to the circumstances of a number of the other deaths that form part of your terms of reference, and it's simply important that these five should be on a par, and that in particular the families of the five should be confident and have the comfort of knowing that to the extent possible all the relevant material is before the Commission and will therefore receive full attention from it. Chair, some of this, as I said, are aspects that arise out of the post-mortem report, particularly in respect of Mr. Mabelani, that haven't been traversed. It's distressing material, and we will shortly be placing before you a further photograph. We do not intend to, you have it, yes. Copies have been given to the other parties. We do not intend to put that on screen. Then, in respect of Mr. Fundi and Mr. Mabelani, of course, their circumstances are to an extent joint in that they travelled in the same vehicle on the 12th of August, and that essential history has already been placed adequately before you. I'll take the position up from 9:55 on that day, when, as we know from the Lonman vehicle tracking system, the Nissan Lavina in which they were travelling came to its final stopping point near the loop. Then events clearly happen very swiftly. There has already been some interaction between Mr. Mabelani and other security officers in respect of the arrangement, but what then takes place is that a line of all the security officers is formed across the road. The strikers continue their advance. Some rubber bullets are fired. They have no effect. The strikers charge. All the others escape with their lives. And you'll remember that Mr. Masibi has described that he ran to his car with his keys in his hand, realized that he would not have time to get in the car and to start it and to drive away, and ran past. Mr. Fundi and Mr. Mabelani made a different call. They got into the Lavina, both of them. And again, from the vehicle tracking system, we know that at 10 o'clock, the ignition of that Lavina came on, evidently in an attempt to get it to start and drive away, and it then went off. And we can confidently infer from that, Chair, that that would be the very instant at which the Lavina was surrounded by the strikers who are now attacking. Presumably that someone, one of those strikers, got hold of the ignition, the keys, and switched it off. The ignition never came on again, and the events then unfolded. There is one aspect that I would like just to mention here, and that is that in the course of the cross-examination of Mr. X, you may recall that I asked him the question, did either Mr. Fundi or Mr. Mabelani have an opportunity to say anything or to plead for their lives or anything of that nature? And his answer was spontaneous. He didn't follow my suggestion of a plea. He said, no, all that they did was to apologize. But nobody was listening. The strikers were attacking. And it is that kind of detail which, in the circumstances we submit, should be accepted as a part of plausible evidence from Mr. X. It adds to what was happening. What we know is that then both Mr. Fundi and Mr. Mabelani are indeed killed in the course of the attack, which continues. Now, it is in relation to the detail of the death of Mr. Mabelani that I would like just to refer the Commission to the post-mortem report in respect of him. Is that being put up? Could we... oh, there it's coming. Thank you. If we can go to page 2 of the report firstly. Chair, you will see there right at the top, general, paragraph 1, height, 1.16 meters. Now, that is not a mistake, Chair. And if you look at paragraph 4, which describes the external appearance of the body and the condition of limbs, it is recorded that there are third-degree 100 burns. That is apparent from the material we've seen. But B, all limbs amputated and fractured. And that, I believe, is an aspect which has not yet been brought to the attention of the Commission. If one then looks at the photograph that has been submitted, I should just source it. It is part of the exhibit series quadruple Z6, and it is within that referenced as DSC 0357. It originally emanates from the SABC hard drive. And that, as I said, with respect, is a disturbing photo. I should just say what it depicts so that everyone who doesn't have the photo will have some idea. It depicts the burnt remains of Mr. Mabelani, which is essentially his torso. It shows that both limbs have been amputated at just above the knee level, both legs, and both arms have been amputated just a short distance from the shoulder. And that, Chair, I
know what caused the amputation. Is it a sharp instrument of some kind? Or is it possibly the burning away of joint material and so on?
All that we have is the post-mortem report, where the doctor has very deliberately used the word amputated, and one looks at the at the terminal points of both legs and arms, and one can see that there has in fact been a severing and not a burning away. A burning away would result in a different picture. One wouldn't have that uniformity of the event. Chair, when I was preparing the presentation of this sort of detail, I had resolved that I would refrain from adding adjectives of my own, and I intend not to do that. But it is part of a request that we would very respectfully make of the Commission, which is that the Commission should take into account this material from having regard to two facets in respect of these events. The one is what was the conduct of the attacking strikers? What did they do? And the second, of course, is to try somehow to place oneself in the position of the persons who were killed at the time of the event, in order to try to gain some sense of what must have been going through their minds, and of course what was happening to them physically. And that we make that submission also as part of the general statement that I made earlier, that when the families ultimately see the report, they will also have the confidence that what happened to their fathers, husbands, brothers, as the case may be, was fully appreciated by the Commission. So what I might have to say is not so important as what the response of the Commission would be. May I then turn to page 1 of this post-mortem report, because there is another distressing detail. Chair, before I go on to that, Mr. Cheskelson has very helpfully just sent me a note. When I described the reference, so that you can find the photograph if you need to on the system, he says the full description should be quadruple Z 6.116 and then DSC 0357. Chair, what is to be seen on page 1 is that paragraph D says the chief post-mortem findings made by me on this body were the following. Black adult male with history of burns, 3rd degree 100 burns, soot in the trachea. And the trachea, of course, for anyone who's not familiar, is that portion that we call the windpipe just below the larynx, which we call the voice pipe. It leads directly into the bronchi, which then disseminate into the lungs. The significance of a finding which the doctor again thought prominent enough to include as a chief finding of soot in the trachea indicates that at least for momentarily or for some short while, Mr. Mabalani was in fact still taking in breath at the time that a fire was beginning to envelop him, which gives one an idea of the extent to which he must have endured the situation before finally succumbing to the 3rd degree 100 burns. Chair, that is, those are the points that arise from this post-mortem that we thought it important to place before you in this fashion. Then, if I may turn to Mr. Fundi, we know that he also, of course, was killed in the course of this event. We know the essence of his injuries, which were a fracture of the skull and also an open fracture of the jaw. There is then, of course, the additional detail which emerges more clearly from the photograph than it does from the post-mortem report, which is that both the upper lip and the lower lip had been sliced off or hacked off. And here I must refer to the affidavit from his brother, Mr. Fundi, which is an exhibit quadruple A40, and you'll recall that his brother conducted the pre-funeral washing and related ceremonies, and he confirmed that he had seen this, he had seen some other injuries, but also he stated that half of the tongue had been cut out. And that is something that needs to be addressed, because there has been not an entirely consistent interpretation of this in the submissions that I've heard thus far. Chair, one with respect can accept absolutely what he has said. It brings Mr. X into the picture again, and we've given the references to this in our written submissions. Where in that paragraph we posed the questions, well, what happened to these lips that had been cut off and this tongue that had been removed? Because they are nowhere to be seen, of course, in the photographic material. And Mr. X, in his statement, says what took place. And he refers there to the tongue having been cut out. And that, in our submission, is something that lends plausibility and credibility to that fragment of his evidence. He says those parts, together with some blood that had been, as it were, drained from Mr. Fundi, went into a plastic bag, and they were taken to the Singoma on the Kopi, and they were used for the preparation of further muti. And why we say that should, with respect, be accepted as evidence is that had he not been there, then he would not have known that the tongue had in fact been
what tends to support that? I just put this again as a prima facie comment. Others don't agree, they're free to make submissions on the point. But the danger with Mr. X, of course, was one didn't know what information he'd been fed by other people. And so the argument that his evidence is confirmed by things that are objective evidence is subject to the criticism that we don't know whether the confirmatory features were fed to him before he made a statement. But if it's correct, and I take it this is implicit in what you're saying, if it's correct that the police and other people in contact with him at the time he made his statements didn't know about the tongue, because it wasn't on the post-mortem material and so on. And if it's correct that that confirmation of that fact only came to light afterwards, after he made his statement, when the brother's statement was obtained, that would be an indication that that detail at least wasn't fed to him, and that would confirm part of his story. I take it that's am I understanding your submission correctly?
Chair, your understanding is absolutely correct. That's precisely the chain of reasoning, and that the post-mortem report, even with a later addendum, really just spoke about lacerations of the tongue, which didn't convey that in fact half of the tongue had been cut out. So it's on that basis particularly, and Chair, you've put it precisely, that we say it is that sort of independent knowledge that makes this plausible. But what is clear is, of course, what happened to Mr. Fundi. Again, I leave those circumstances in the hands of the Commission for evaluation. Then, if I may turn to Mr. Mabebe, here there is a good deal of the information was traversed, albeit briefly, by me, with particularly Mr. Blow at a stage when we were seeking to unfold a number of features of what had taken place that hadn't been otherwise dealt with, to do so even if briefly, rather than not at all. And Chair, there, if I may just summarize it on the same basis as I've dealt with Mr. Fundi and Mr. Mabelani. Mr. Mabebe, as we know, comes to work. He has no reason to expect anything of the nature that in fact unfolds when he arrives at K4 Shaft. Perhaps he's bewildered when the attack begins, but very soon he would realize that he is in fact a target. He is very seriously and quite viciously attacked, and we have those details. There is a terrible fracture of the skull with brain extrusion. There is a fracture of the jaw. There are 5 stab wounds. 4 other people are injured. Mr. Janse van Vuren, who gave evidence, says that his life was saved only because his windscreen kept a heavy steel pipe out. They all go to Andrew Safi together in an ambulance at the same time. But what is important to appreciate in respect of what Mr. Mabebe went through is that those terrible injuries don't kill him immediately. So that after the attackers have gone and Mr. Janse van Vuren sees that he is lying there next to a vehicle which is now burning and drags him a little distance away for safety, Mr. Mabebe is still conscious, and Mr. Mabebe is still able to say quite clearly to Mr. Janse van Vuren something about the dreadful pain that he is in. And Mr. Mabebe, as we know, is still alive 1.5 hours later when he gets to Andrew Safi, probably by then in a situation of extremis, and dies, we're not sure when, but not too long after. The question of the treatment of him, medically speaking, is not in focus at the moment. It is really just what he would have experienced in consequence of that attack on him. Mr. Langer, Mr. Julius Langer, we know even less about in respect of the circumstances. I heard Mr. Mpofu, my learned friend, Mr. Mpofu, suggest yesterday that this might have been just 1 or 2 people who set on him. In our submission, the probabilities are that that would not have been the case, and that this was part of the general attempt, the general exercise that was being conducted at that stage, which was to intimidate people to the extent where they might die, and that Mr. Lange was one of those. And partly why I say that is that what we do know about Mr. Lange is that he sustained 18 stab wounds, including a series of deep penetrating wounds involving the spleen, the stomach, both lungs, the pericardium, the heart, the liver, and the only thought that I would identify perhaps for further consideration by the Commission is that it may be easy to say, well, there were 18 stab wounds. What is less easy with respect is to form an image in one's mind about how 18 stab wounds come to be inflicted on one person, just what the nature of that event is. And that is why we say this was not a fracas or some incidental argument between Mr. Lange and some other person. Then Mr. Twala, there's an aspect there that needs to be given some further attention. Mr. Twala, of course, we have some description of what took place there from Mr. X, who essentially describes that Mr. Twala was called up, as it were, that there were accusations made, and that he was then taken away and killed. Mr. X wasn't at the place where he died, but that's his essential sequence. Now, what I'm going to take the Commission to is a portion of the evidence in chief of Mr. Nzuza, and to examine what he said about that. And I will seek to demonstrate that from that it is quite clear what took place, and that the evidence of Mr. X, to which I've incidentally referred, is in fact not critical for a finding in respect of what took place. Could we have, please, the transcript, day 277, beginning at page 35513.
What line do you want?
From line 11. As I said, this is the evidence in chief, and I'm going to read the full passage, if I may, and then seek to draw the inferences that I say, with respect, should be drawn. So, my learned friend, Mr. Mpofu, is leading. He says, "Okay. Then later on the 14th, there is evidence that the body of Mr. Twala, or a body, you might not have known the person's name, was found near the Kopi. Do you remember that?" I remember that. Mr. X says you were involved in that incident. Can you explain what? Well, firstly, were you involved in the killing of Mr. Twala? No, I was not there. Okay, did you see Mr. Twala, or the person that we've now seen in Exhibit L as Mr. Twala? Did you see him on that day? Yes, I saw him. What happened? Can you just briefly tell the Commission where you observed him? And how you observed him. And then this is the important part. Mr. Nzuza says, "I did not know who he was, what his name was. I just knew that he works at Forbelt. When I went there, I arrived, sat next to Mambush, because he was standing on his feet and talking. And I just heard him saying, quote, 'The person who knows me,'" this is clearly Mr. Twala who is speaking, "'the person who knows me is this one, this boy sitting here. He knows where I work,' and so on." Unquote. And that's when I said, "No, old man, don't say you know me. I only met you once, one morning when I came off duty, and you wanted goggles from me, goggles or sunglasses from me. And that's when I responded to him. I said, quote, 'I only met you on that day. I did not know you, and you said you'll cause me to be fired,' unquote. And that's when I left, stood up, and went to a place where I was having a cold drink on the side at the Wunderkop. Yes, and did you see him or talk to him or interact with him at any other stage on that day? No, I did not see him again. I just went to sit on the other side." Now, we're not here going to address the question of whether Mr. Nzuza's description of how he left is accepted. We accept it for this purpose entirely. But what is important is that Mr. Nzuza's account of the exchange, while he is present with Mambush and Mr. Twala, is that quite clearly Mr. Twala is in fact facing some kind of accusation, presumably headed or led by or made only by Mambush, and that his credentials in a sense are at issue. And there, particularly in context, of course, it would be what is he doing at the Kopi? Is he a genuine member of the strike? What is he doing? And that is why one has in that account Mr. Twala saying, "But this boy knows me. He knows me. He can tell you about me." So clearly, what is happening there is that Mr. Twala is seeking some kind of voucher to be given in respect of who he is and that he's a real worker, etc., etc. He doesn't get it, as it happens, from Mr. Nzuza. Mr. Nzuza says, "No, I don't actually know you." And then perhaps somewhat inconsistently, he says, "There was just this occasion when you wanted something from me and I didn't give it to you, and you then said, well, Twala will see that he, Nzuza, is fired." Now, Chair, what the essential inference that I respectfully submit is to be drawn from this is that is indeed a characterization of what Mr. Twala's position was at that time. He was under challenge. He was seeking to find some kind of support and corroboration and vouchsafe. He didn't get it. Now, that's all we know about the interaction. We know nothing about any further discussion. But
did he not get it? He got an accusation of some kind of hostility to Mr. Nzuza. Statement that he would cause him to be fired. So far from getting positive support, he got something negative from Mr. Nzuza, which would strengthen the fact that in some way or other Twala was under hostile scrutiny, potentially hostile scrutiny.
Thank you, Chair. Indeed, that emerges very clearly from the latter part of that exchange.
Mr. Tip, I recall in the docket dealing with Mr. Twala's death, there are statements from witnesses, not Mr. X, and not warning statements, that speak of this very issue, where Mr. Twala is being questioned and someone is asked if he knows them, and the reply is yes, he's the person who used to discipline us. So there is some corroboration for this version.
Quite correct, Commissioner Hemorrhage. That is to be found there. So this is not uncorroborated. The
factor, actually, Mr. Tip, I don't know whether you rely on it. It may be not appropriate for us to rely on it, but I put it to you, forget your comment. He was a NUM office bearer, and whether he was really acting as a kind of spy, or whether he was not, the fact that he was known to be a NUM office bearer might well, this may be speculation, I suppose one must be careful, might give rise to the inference anyway, that he was viewed with suspicion because he was a NUM office bearer, and there was some kind, even though some of the people on the Kopi were NUM members, it does appear, I would think from the leaders, as it were, there was from the leaders hostility towards NUM because there were the events of the 11th and the 12th, in fact it was said that they'd been attacked by NUM. That's why they were carrying weapons to defend themselves against them. Now, here's someone who's a NUM office bearer, and if his loyalty to the strike cause is not entirely accepted, then that would explain the hostility to some extent. But I don't know, it may be dangerous to put too much weight on that.
Chair, thank you. It may well be that that was a factor, because if you're an office bearer of any union, people are aware of that. But I would, with great respect, seek to position my submissions on a basis that excludes that consideration, because there seems to me to be an inexorable line that has to be drawn from the exchange that we see in the evidence in chief of Mr. Nzuza and what happens to Mr. Twala, which is also objectively entirely beyond dispute, which is that he is killed. And we know that the spot where he is killed, it is approximately 100 meters towards the back of the Kopi, away from where the workers, the strikers were gathered. And it, of course, is clear that Mr. Twala would have been taken there by those who killed him. If that is correct, then there is the critical intervening moment, the decisive moment, rather, not the intervening moment, the decisive moment, when a decision is made that he is to be taken away and that he is to be killed. Because that can't happen as a matter of spontaneous action by a couple of people who just take him off. In our submission, the probability then is that somebody, whether an individual or a small group, somebody makes a decision. Really, it would be a cold-blooded decision that he, Mr. Twala, is to die and he's to be taken away for that purpose. The death, of course, as we know, is also a horrible event. Well, all deaths are horrible, but there's a particularly horrible aspect to it. He too suffers a number of stab wound injuries, 13 in total. But what particularly characterizes his death is the placing of this bleached skull and horns of a cow or an ox on his chest. And what we say about that is that it, again, on balance, can be nothing other than a final violation of Mr. Twala as a person, even with his passage into death. It is, of course, consistent with the notion that a decision has been taken that he should be put to death because his position on the Kopi is found to be unacceptable. That is as far as we can take that on the available facts, but we do submit that there is a continuum there that makes sense only on the basis of what happens with Mr. Nzuza's evidence, albeit that Mr. Nzuza then leaves the scene, he says, to the point of death. Chair, those are the matters that we sought to place before you in respect to these deaths, and I won't enlarge on them collectively at all. If I may proceed to the next topic, which is the issue of collective bargaining. This has been addressed. I'm going to condense what I had prepared to place before you here, because we've dealt with it in our written submissions. We've set out some portions of the Constitution. We have set out some extracts from the Labour Relations Act, the LRA. Lonman have done the same. My learned friend, Mr. Berger, dealt with those in the early stages of his submissions on Monday. And I'm not going to repeat those. All I'm going to underline there is that there is a very distinct and very important statutory framework that bears on all these events, with the Constitution and its values as its bedrock, and then detailed provisions in respect of how collective bargaining, inter alia, how collective bargaining is to be done, how the rights conferred by the Constitution are to be protected and advanced. Why we say this is a departure point for these particular submissions is in part that paragraph 1 of your terms of reference, if I may just read that, it begins as follows. Well, it says the following. The Commission shall inquire into, make findings, report on, and make recommendations concerning the following, taking into consideration the Constitution and other relevant legislation, policies, and guidelines. Excuse me. We say that what that underlines is really a very important orienting consideration, which is that one has to bear in mind that all the events that have been inquired into, particularly over the 9th to the 16th of August, have arisen, have developed, have unfolded, and finally all take place in a workplace. And that workplace is to a very substantial extent governed at the level of how labour relations is to be managed through particularly the LRA. So in a sense, if one were to pose a question along the lines of, well, to what extent does the Commission need to have regard to things like labour relations, then our answer would be to a fairly substantial extent. Of course, it's you're not dealing with an inquiry into labour relations only. That's a different matter. You're dealing ultimately with all the violence and the deaths that ensued. But our submission is that in order to accurately position that examination, it needs to have regard to precisely where it started, in the sense of what breakdown, if there was one, in the labour relations environment led to the kind of increase of hostility, the breakdown in communication and relationships that in turn produced a situation where violence and mayhem really became what they were. So it's in that context that I make these submissions, and I'm going to very, very summarily deal with one or two supplementary aspects. The one is that we've set out in our written submissions various sub-paragraphs or subtopics concerning collective bargaining and how it works and the role of mandates and so on. None of that I'm going to reproduce in these oral submissions unless there's a particular area of query. But what NUM's role in all of this is, of course, an important role, and it needs to be examined closely and appreciated closely, and part of that entails the very full description, albeit in fairly summary terms, that spanned the entire exercise of NUM's approach to collective bargaining. Again, I'm just going to highlight that it begins with a process of obtaining demands and processing them at section level, at shaft level. It's grassroots. It's not imposed from above. There is then an elaborate but effective process of these being evaluated, condensed into a set of provisional demands, which then go back to a mass meeting for a set of demands finally to be approved by the workers in that mass meeting. NUM being what it is, which with respect is that it is a mature union, those demands then go into a head office process where they are assessed in terms of a whole range of considerations relating to the financial and economic strength of the sector and the performance of the companies and so on. And ultimately, they come out of that, and if they're approved, the negotiations begin. Those negotiations then with the company have been described also by Mr. Gilichana, and they conclude ultimately with the obtaining of a mandate from the workers in a mass meeting. Only then can a collective bargaining agreement be entered into. Now, that happens at Impala, and as the Commission knows, a collective agreement is entered into there on 7 October 2011. It takes place also later at Lonmin, and there is a collective agreement dated 2 December 2011, but effective from 1 October 2011. As that, there's absolutely nothing to suggest any level of complaint in respect to the content of those collective agreements over several months, particularly at Impala, which is the critical one because that's where the first derailment, as it were, takes place. So
when did they give the rise to the certificated miners?
that's the point, Chair.
When was that?
That's the very point I'm coming to, Chair, if I may. And that's a critical factor. But just for a moment before I get to that, which is 18 December 2011, what I want to submit is that actually as at mid-December 2011, the entire Platinum Belt is working. Collective bargaining has functioned. There are collective agreements in place that are being respected and applied. And we're now shortly before the long break over Christmas and New Year and so on. Other than incidental issues around, say, AMCU and NUM and recruiting at Lonmin, which are of no consequence in the present context at all, everything is running smoothly. 18 December 2011 is the critical fracture moment, because that is when Impala management take the unilateral decision that all certificated miners are to receive an increase, and it's a substantial increase. AMCU's council have described it quite appropriately as a whopping increase, and it was, for one particular group of employees. Why? Because Impala management have come to the view that other mines in the area are paying that category of worker better, and they are concerned about losing some of those workers. They're not concerned about anyone else. And that is why they single them out for this unilateral substantial increase. No consultation, no negotiations, no forewarning. It's simply done. And of course, as one knows, and we see echoes of this in Lonmin, how do these decisions get taken? They get taken by commercial management, essentially, who say, well, if we don't do this, we may lose those people, or some of them. And if we lose some of those people, our production is going to be severely affected because they are critical to the process. Only they can insert explosive charges, etc. What will it cost us to get back on par for those people? What will it cost us if we reopen negotiations? Oh, well, that's we're not going to deal with it. So it's 18 December, and all of my colleagues who practice in the field of labor law will agree with what I'm about to say. When decisions of this kind are taken, very often timing, of course, is critical. What will be the impact of what we're about to do with this unilateral decision? And I'm saying this, of course, on a speculative basis, Chair, but with some confidence in respect to what happens in practice. Let's do this just before everyone goes away for the break, and hopefully by the time they come back, we'll just continue. The miners will be with us still, and life will go on. Now, of course, that doesn't happen at Impala. There is a swift reaction to this, and it happens, if I may borrow a phrase from the article that was put in from Mr. Hartford, although he was talking about NUM, in fact what takes place is that on the foothills of Lusikisiki and Flagstaff, the RDOs discuss what has happened. The miners don't discuss it, they're happy. The RDOs discuss it, and far from Impala resuming with a contented workforce and peace around this unilateral increase, come January 2012, when people return, there is almost instantly the demand from RDOs for 9,000 rand basic wage. But that demand, of course, reflects in part anger with Impala as to what happened. But unfortunately for NUM, it also then turns into very, very substantial anger with NUM. And Mr. Gilichana has dealt with all of this quite fully in his statement. You may recall that, of course, he was the chief negotiator for Lonmin, not for Impala, but he's in contact with the people, the NUM people at Impala, to the extent that it's hearsay, that wasn't a problem, and none of it has been challenged. But he underlined the following. He says, why do people become angry with NUM, where Lonmin, I beg your pardon, Impala, has unilaterally made this major differential increase to one category of employee? Well, they're angry because they say, during the negotiations, during the time that led to the conclusion of our agreement in October 2011, NUM was coming back to us in the feedback meetings and in the mandate meetings, and it was saying, we've negotiated hard for you, and Impala can't do better. And now suddenly they can do better. And workers, Chair, have very well developed antennae when it comes to collective bargaining issues and regularity of process. And where there is a demonstration that something irregular has been done that in fact creates a differential and operates to their prejudice, they identify it immediately and they react immediately. If they feel that there is a lack of bona fides, they pick that up and they react to it. So when NUM has said to them, this is what we've been able to achieve for you and nothing more, the coffers aren't empty. Therefore, you haven't actually done the best you can. And there was...
We're coming to that now, that among the beneficiaries, among the miners who got the increase, were the NUM negotiating.
Well, that was the second point I was about to make, and it's a very, very important, we say, coincidental, aggravating feature. So it wasn't so much the negotiators. It was that both chairpersons of the two Impala NUM branches at the time were certificated miners. But that's sufficient for a wave of rage to spread. And we have seen repeatedly and frequently in the consideration of how views get disseminated at Lonmin, and the same happens at Impala. You've got workers who live very close together, and it just requires one or two people to say, but you know what, NUM said there was no more money, but what happens? The two chair people of NUM, they're getting this 18% extra, and they're betraying our cause. And said Mr. Gilichana, that gave rise then to this duality of anger, partly directed to Impala, but of course by far the more immediately available avenue for expression of rage is the union. And hence he says very swiftly this demand for 9,000 rand very predictably also turned into an unprotected strike, and that was a very violent strike also. And a lot of that violence was directed against members of NUM and the officials of NUM. The NUM's officers were attacked. NUM officials had to leave for their own safety. So it becomes really a very fragmented and dangerous environment when one looks at it from the key through the key lens of collective bargaining. There has been a breakdown, and that breakdown is anything but cured. When in April, if I remember the date correctly, April 2012, Impala again unilaterally announces a set of across-the-board increases now in order to bring an end to this unprotected strike. And that includes promotion of RDOs. It includes, again, the benefits, wages that are increased, time periods in the collective agreement are brought forward. Very substantial advantages ensue. And why, again, that is a particularly exacerbating feature of a breakdown, of a fissure in the collective bargaining environment, is that all those strikers, and as happened later at Lonmin, this became not only a strike of Impala RDOs, but a strike of all workers at RDOs. Everyone gathered, and as it happens, everyone received benefits. Perhaps the RDOs, of course, got the largest because of their category promotion, but everyone benefited. So one has a process where collective bargaining has simply not been observed in the most fundamental way possible. The breakdown, the first unilateral increase triggers an unprotected violent strike, which is brought to an end by, again, unilateral management decisions, and all those strikers have seen the message. Forget about the union. Forget about collective bargaining and everything that is involved. Just do it yourself. Violence will accelerate a response, and that's the message. So that is why we say that, far from being just a somewhat distant parallel in some respects with what took place at Lonmin, Impala demonstrates very, very clearly what happens when the collective bargaining regime, when the statutory framework is breached. And that's a problem. So may I then turn to looking at what happens in Impala, I beg your pardon, Lonmin. Now, interestingly, Chair, what we know from Mr. Da Costa is that as at 21 June 2012, which is, of course, another key date, when the first two RDO representatives, when the first small march takes place to his office, as at that stage, Mr. Da Costa has been receiving reports from within his management and security environment that RDOs at Korea have held a number of meetings at Korea, but they've been very poorly attended. And why? That's paragraph 3.6 of his main statement 0017. Why that is significant, Chair? We're now talking about June 2012, several months after the conclusion of the strike at Impala. But even at that stage, Lonmin is essentially functioning without difficulties on the collective bargaining front. The collective agreement of 2 December 2011 has been in operation without difficulty for some 7 or 8 months by then. Well, longer, going back to 1 October. And in short, what one can say about it is that the situation at Lonmin was in fact not just a bed of dry tinder which would ignite upon the merest spark arriving. So Impala didn't immediately trigger the events at Lonmin. I must underline the word immediately, because clearly it does play a very clear role in the sense that the way things happened at Impala become the way that things happened at Lonmin, but they're not immediate. And that is important when one looks at the response of Lonmin to the approaches at Korea. Now, we know, and perhaps we can just call up on the screen, please, XXX3. if we can go to page 5, I think, of that bundle. Yes, that's the document. Just go back a bit. Page 3, I'm sorry. Yes. Chair, I'm going to look at just a few aspects of this. This you'll recall is the memorandum that Mr. Da Costa sent through to EXCO at Lonmin shortly after the first approach to him on 21 June. This is dated 27 June. Now, what before I get to that, Mr. Da Costa was cross-examined quite extensively in respect of various aspects, including the. Sorry, let me just check. I just want to check my my consumption of time, Chair. Sorry. Oh, okay, that's fine. I've got time to deal with this, Chair. Mr. Da Costa was cross-examined by a number of people, including myself, on the response of he himself, and then, of course, Lonmin as the company, to the approaches by the career RDOs. And I aligned myself with what I had already heard, which was that Mr. Da Costa's response to them initially was absolutely appropriate, namely, that he saw them and that he met with them and that he established from them what it was that was their concern. And let me just underline that. It's a theme that I'll echo once or twice again as I go through this topic. Why it was appropriate for Mr. Da Costa to see those employees is because collective bargaining and labor relations generally, as a philosophy and as a management framework, has also gives very clear recognition to practical considerations, such as what on the basis of an ordinary sense of fairness is appropriate to do in a particular situation. What in terms of an ordinary cultivation of relationship and the prevention of immediate frustration is acceptable. And that is why when Mr. Da Costa sees the RDOs that come to him as at 21 June is not to be faulted. Then there is his reaction. Now, Mr. Da Costa, as we know, was in fact a member of the negotiating team for Lonmin, and he showed himself in the course of cross-examination on various topics relating to labor relations to be well informed and to be sensitive to actually what the entire paradigm is supposed to achieve. That understanding by him is reflected in important ways in the memorandum that he sends through to Lonmin. Let me, sorry, if I may have a moment. Just to get my copy. On the following page there, if we can just go one page down. Yes. Under the rubric there of proposal, this is now what he is suggesting to EXCO. He says, I suggest that, I propose that this is how we deal with it. And the first one is, feedback will be given to the two representatives who met with the Vice President as follows. And the first bullet point is the only one that I'm going to underline. Lonmin has well-established processes for the negotiation of wage increases and other conditions of employment, and is not in favor of ad hoc negotiations taking place outside of those processes. Now, that is a very important statement for Mr. Da Costa to make to his EXCO, because he very succinctly there highlights a core aspect of sound collective interaction, sound labor relations. And that is that the agreed structures have to be respected. They have to be cultivated. I said a few minutes ago that workers are very sensitive to derailments, demonstrations of bona fides. Workers are generally requiring reinforcement.
I apologize. If it wasn't my phone, I would have caused the owner to be evicted from the chamber. I can't do that. I'm sorry.
Perhaps I might say that you have to excuse yourself for 15 minutes while we take a first comfort break.
Are you suggesting I take the tea job now?
We'll defer it, Chair. Thanks. Okay. So, Chair, this is collective bargaining involves. If I may just take a sideways step for a moment, in order to underline very, very prominently why this is a correct statement. Collective bargaining is, in a sense, of course, a regime that has been structured through policy dimensions. It's a very important regime, and it goes all the way back to the certification of the Constitution itself, where the Constitutional Court said, well, collective bargaining is there as a means of equalizing the power balance. Because employers on their own, of course, have all the power. Employees on their own have no power. It is only when they come together that collective bargaining can take place, and only when they come together properly, of course, that they can enforce their power through a strike. The structure envisages only lawful strikes, protected strikes. Again, huge problem when it's an unprotected strike. But it's that equation. But there is also inevitably the dimension that there has to be majoritarianism when it comes to the formulation of demands. So that if you have a collective bargaining arrangement and a union, or more than one union possibly, which is formulating demands, then, as happens with NUM's processes which have been outlined, you will have different demands from different sections. Somehow they all have to be reconciled. And those who wanted an increase of 23% have to be reconciled with those who are content with an across-the-board increase of 14% as an opening gambit. So there is this give and take. And that is why, in a sense, there has to be continuing cultivation and protection of the mechanism so that the buy-in by all workers is maintained. Now, that, coming back to Mr. Da Costa's statement that we see there, if one begins what he correctly calls a process of ad hoc negotiations, then of course there is immediately the process of the fracturing of the collective coherence of the process, because then it becomes open for ad hoc groups to formulate their own demands, and the entire situation becomes precisely what the statute doesn't envisage and what the policy doesn't desire. Incidentally, if I may just jump ahead for a moment, we saw a very clear illustration of that at Lonmin, and you'll recall that after the RDOs had their series of interactions with Mr. Da Costa, and through Mr. Da Costa with EXCO, a group of team leaders came to see him on the same basis. They also had a set of demands. Well, that was easy to deal with because there are only 15 or 20 team leaders, and they're not RDOs, they're not drilling the rock face, and they're not certificated miners, and they're sent away. But it's precisely that kind of process that is always the latent peril when one starts to diffuse the the integrity of collective bargaining. So this is really a ground rule, and it needs to be viewed in precisely that term. This is the ground rule, and Mr. Da Costa is saying to EXCO, our feedback must tell them that this is the ground rule. Now, as soon as you establish that ground rule, then of course one has to examine what is the best way for this particular situation to be dealt with. And if I may go on to the next, if you just scroll up the page of fraction, please. Sorry, I mean downwards to the lower. Yeah. In keeping with that general statement of the ground rule, Mr. Da Costa then says, this feedback will be given on 2 July 2012. That, of course, you'll recall is the date on which he is scheduled to meet again with the RDOs. Then he says to EXCO, the feedback outlined above is not likely to resolve the matter. Again, critical statement, and showing a real astute understanding on the part of Mr. Da Costa of what the likely dynamics are of what has begun by this first approach to him on 21 June. They're not likely to resolve the matter. More work will be required over the next few weeks in this regard. The following is proposed. Bullet number 1. Critical. Engage both the NUM and AMCU at national level to inform them of this development and to solicit their opinion on the matter. Now, that again, that is something that certainly I and I think others also in the course of the cross-examination of Mr. Da Costa indicated that too indicated a thoroughly sound grasp on his part of how this situation could be approached in a constructive way and in a way that would maintain its coherent relationship with the overall framework. There are a few elements that need to be identified here and singled out. First of all, he says, engage both NUM and AMCU. Now, that, of course, has a real recognition for what was a factual complicating feature at Lonmin at the time, which was that NUM overall remained the bargaining agent for the whole of Lonmin. NUM was at that stage certainly still well entrenched as the majority union at Eastern Platts and Western Platts, but AMCU had most certainly become the majority union at Korea. The RDOs were from Korea, so he is recognizing a practical situation, and here I echo what I said a while back about common sense being a very vital component of a sound labor relations practitioner's approach. It's common sense. The second important feature there is that he says at national level, to be underlined and to be endorsed. And why that is important is that there is an appreciation that the relationships at Korea can't easily be addressed at a local level and be resolved at a local level. He also understands, does Mr. Costa, and this is an important point, that the wage agreement has been entered into at a national level. Mr. Gilichana is the chief negotiator. He is a national office bearer of NUM. Negotiations aren't conducted at a place like Lonmin at branch level. There are representatives from the branches in the negotiating team, but no branch has the authority to conclude or to amend a collective agreement. Then he says, again very constructively, inform them of this development, tell them what's happening, and finally, and also with insight, he says, solicit their opinion on the matter. Opinion may be a formalistic word, but essentially what he is saying is that we've got a complicated situation here. Get both unions at national level involved, get their views. Now, had that, and perhaps just for completeness before I adumbrate on that, Chair, at the conclusion of the memorandum, if we can just go to the next page briefly, Mr. Da Costa also says to EXCO, engage with the NUM at AMCU at Marikana to reach an agreement on the matter. And of course that is essential as well. You've got to have buy-in at the local level, but the input in respect of something like the status of a collective agreement cannot come from the local level. Now, Chair, why that approach set out in this memorandum to EXCO was a promising one, had it been observed, is that it would have immediately drawn in NUM and AMCU at a formal level to give their views. NUM nationally would have come in, and it would have looked at the entirety of the situation. It may have begun by having mass meetings at Eastern Platz and Western Platz. That in itself may dramatically have changed the course of events. But what would then happen is that NUM and AMCU would have to address the situation of the de facto demand that had come from RDOs at Korea. And that then sets up an entirely appropriate dialogue process. Now, we can't pretend, Chair, that would have simply been, or that would have been a simple interaction. AMCU is seeking to augment its position. NUM is seeking to defend its position and perhaps reclaim membership. So there are those sorts of considerations that would doubtless also feed into the interaction. But once that approach and once that interaction has been established, then those parties, all three parties, in fact all four parties as it were, NUM, AMCU, Lonmin, and as a distinct entity, albeit not without formal status, the RDOs at Korea, then need to address what is a common problem. I recall that at one stage in the cross-examination of Mr. Costa, he was asked a little about, well, how would all this work and so on, and he said, well, of course, a lot of attention would have had to be given to how any negotiating forum could be established. So he was well aware of the need for sensitivities there. But what it would absolutely have crystallized would be a response at that level to that situation from these two unions. And after that, well, things unfold. One can't predict what would have said, but then the further process, of course, develops from that position. That is what happens in labor relations. One makes the first move in accordance with sound principle. The second move has then to take place, hopefully also in accordance with sound principle, but it moves. And that's the key thing. So, Chair, what I should just add here is that you'll recall that Mr. Kilichana described that NUM would have been happy to discuss outside collective bargaining at a certain stage, but it's correct for me to make this point that was in the context of what had happened already by mid-August 2012. So I say that only to avoid an inadvertent translocation of that bit of evidence as perhaps being what NUM's attitude would have been at 27 June. It was never canvassed, and AMCU's views were never canvassed in accordance with that suggestion, because EXCO then took a different route. And perhaps, Chair, I can turn to that after the brief adjournment.
Thank you, Mr. Tip. 15 minutes.
You are giving them an education.
Well, that's the point.
To understand how you function.
And the bit on Nabelani and Twala? Huh?
No, it was appreciated because up until now we glossed over those things. So we've had Jennifer showing pictures of the team. Yeah. Heads blown off. One also said
resumes. Yes, Mr. Tip.
Thank you, Chair. If I may continue, I'm about to turn to a consideration of what EXCO decides, but perhaps before I do that, I should say one or two things further about Mr. Da Costa's proposal about getting the national unions at national level involved, and there is a point to be underlined there as well. One is seeking to bring in those unions, each of which have status at CREA. AMCU is already recognized in respect of a wide range of entitlements, and the importance of bringing them in and getting into action with them going is that it also would inevitably clarify the position of the RDOs. And one of the particular matters that would, of course, necessarily be addressed is the position of the RDOs that they do not want any of the unions involved. Now that's a key proposition, and there comes a time in labor relations and industrial management of this kind and the preservation of collective bargaining that one has to be firm, and a company has to be firm. So this is, in fact, implicit in all of this is that there has to be a moment where the statements that are made to the RDOs by Lonmin, that Lonmin won't negotiate outside the collective structures, has to be given force. However, what is critically absent in what happens once the matter gets through EXCO is that interaction is extinguished before it starts, actually. And as soon as you remove those two unions, AMCU and NUM, at national level, you remove an essential couple of ingredients that must go into the pot of formulating a practically workable formula for moving forward. And then you leave, as happened here, you leave the RDOs on their own. It's their declared route, but it's an unacceptable route. We know that from the ordinary philosophy of labor relations, and we know that from what actually happened at Impala, where precisely that remained the position. There too, there was no engagement of the unions. So there does come a moment when one has to say, well, we will not, in fact, bargain with you because you are outside the collective structures, but here is an arrangement which has been devised to everyone's satisfaction between the two unions, Lonmin, and now it's up to you. And if workers who are acting outside of these structures with the already clear intention, and that is something that Mr. Da Costa perceived immediately right from the start, he was concerned that underlying all of this was the prospect of industrial action, as he put it, unprotected strike action, as he developed it in his evidence. As soon as you've got that prospect, then one has to take an in-principle position that will deal with it. What EXCO does, to come to that now, is in effect to ignore this triumvirate of recommendations from Mr. Da Costa that I've gone through already. And they do what we submit Impala management did. They sit and they look at the thing from a commercial perspective. And there is that very unsatisfactory bit of evidence that at one stage they ask for an opinion on what will be the consequence of reopening collective bargaining, and then it's just dropped as a topic. It's never taken anywhere. What they do look at is, well, what are the present relationships between what we are paying RDOs and what other people are paying RDOs, and what will it cost us to bring us back into parity so that we keep them? And then you get to this utterly unsatisfactory formula of an allowance. Unilaterally determined, not put on the table for discussion. It's ex cathedra. It is EXCO saying, well, this is what you're going to get, and of course it doesn't save the day. Chair, perhaps it might be useful for me just to take a moment to say something about the idea of an allowance, because it may sound like something that is neutral, but of course it isn't. Not in the context of labour relations and collective bargaining. An allowance, like any other term and condition of employment, is subject to negotiation. And that is why one sees, for instance, in the collective agreement that we're dealing with here, there is an allowance, a living out allowance. It's negotiated. It's increased, or it stays the same, whatever. Mr. Gilichana has given evidence that it was the practice at Lonmin that even when matters such as bonuses came up for discussion, a task team would be set up, a joint task team, which would investigate it. It would produce figures and data and possibilities. They would then be negotiated and some agreement would be concluded. Now that's important. What EXCO did was to say, well, this is an allowance, as though an allowance is somehow immune from collective bargaining, and it isn't. That an allowance doesn't really fit into your wage structure, but of course it does. And technically it does, and with respect, Chair, more than once you have said precisely this. But it's part of their remuneration. They would perceive it as part of their remuneration. Of course they do. But by definition, in terms of the Basic Condition of Employment Act, remuneration includes all payments in cash or in kind that form part of the package that a worker receives. So this is remuneration, technically so, and it has to be dealt with so. But the fundamental problem with what EXCO did was to actually keep the RDOs in an isolated stream, to recognize them in their position as an isolated stream, and by isolated stream I mean maintaining their declared position of having nothing to do with the unions, and at the same time then to say to them, well, we're not going to talk to you. So you don't do what Mr. Da Costa did, which was to set up on a joint basis a forum that could address it. That's discarded by EXCO. It says, here's an allowance, take it or leave it, and we're not going to talk to you. Well, that, with respect, is a formula for catastrophe. We know that it became such, but it was also, on any reasonable interpretation and view of what was taking place at the time, going to be a formula for catastrophe. So it is what happens, Chair, when one has these very deficient views in respect of collective bargaining taken by management. Chair, you've remarked, if I may respectfully echo it, that even in the unlikely source of the Lonmin occurrence book, security personnel are saying, but we have difficulty. Management is sitting in the office. They say these things. We then have to deal with it. So it was recognized by them that this ongoing refusal, admittedly that was into August, but precisely the same consideration applies as at 21 June, 27 June to July.
Mr. Tipp, previously when allowances were granted, were these the subject of these discussions and negotiations with the unions?
No, not at all. No, these were not. You see, this is, it of course should have been, but what was, Commissioner Hemraj, if I may just say, that you underline again an important differential that should be clarified. I've explained that allowances of this kind, even if properly so called, would form part of remuneration. They would form part of the negotiation framework, like any other allowance. If I may just take another sideways step, and I'll come directly back to your question. An allowance has a historical place in labour relations, and historically, of course, one had a tool allowance for journeymen, or a travel allowance for people who had to come long distance to perform their work, or possibly even a heat allowance for people who worked in particularly heated environments that pose dangers and so on. Those were all classified properly as allowances that were paid in order to facilitate you coming to do your work. So a tool allowance, you do the work, you're using your own tools, you get an allowance. The wage is something different, and now I'm coming directly to your question, Commissioner. In truth, this allowance was an increase in the wages of RDOs. It doesn't pretend to be anything else. It simply says, well, here's an allowance. It doesn't say a risk allowance. It would have to be negotiated anyway. But in truth, it is an addition to their wage. And the wage, of course, is absolutely at the core of every negotiation. There's a side effect, incidentally, here, that if as an employer, you call part of the remuneration an allowance, when you negotiate, as we have seen both at Impala and at Lonman, the union will come and it will say our opening demand is an across-the-board increase of 19%. That's 19% on the basic wage rate. If half of that is called an allowance, then employers are entitled, if it goes through on that basis, to 19% on half of what they're actually getting. So these are not just minor distinctions in terms of description. They have real consequences. I'm not suggesting that Lonman's EXCO was necessarily looking at it from that point of view, but over the long run, it's important, and again from a worker perspective, because workers understand this, that if you get an increase in your basic wage rate, then that forms a new table. It's a baseline. And every percentage increase that you get over every year of negotiation is a percentage increase on that baseline, and the entire baseline moves up. If part of that baseline lags behind because it's called an allowance, you're actually moving up with less. And at the end of the day, as the increases unfold, it's like compound interest. You're actually getting less. So they're aware of that as well. But it is fundamentally, in terms here, we are really at the interface, Chair, of the considerations that stand at the interface between the violent events that you've been examining and the labour relations departure points that contributed materially to it. And it is this moment where EXCO fails to deal with it on a collective interactive basis, makes an unilateral grant, which is refused, and then reverts to the position that we're not going to talk to you because you're not part of the collective bargaining. Mr. Da Costa's memo, if I may just echo it, and I hope I'm not repeating it unduly, Mr. Da Costa's memo of 27 June, when he says, get hold of AMCU and NUM at national level and get their views, that would have avoided what subsequently happened, because there would have been interaction. One way or another, there would have been a result that would have been sound and acceptable. So a very important moment, Chair, in the context of this. The last point, if I may deal with it in the framework of collective bargaining, is that, again, philosophically and in terms of the constitutional and LRA imperatives that we've already looked at, that framework is geared towards non-violence. Everything about it seeks to prevent the generation of non-violence. And when you break it, of course, you open the way for violence, because you open the way for unprotected strike action deliberately being pursued by people without any regulatory influence, who understand that if there is enough build-up of pressure because of violence and destruction, at some point somebody will talk to us and we'll get what we want. It's not incidental. It's understood, and that is why when, even at the seminars, we refer to them in our written submissions, one has this understanding that this is how you do it. How do you? What's rule number one with a strike and solidarity? Well, you make sure that nobody breaks the strike. You intimidate, and there's violence, and that's recognized in the academic journals, and we have seen it here as well. So that is why these things are of such importance. But the particular aspect of that I want to underline is what I had begun to say, that the framework as a whole, collective bargaining philosophically and statutorily, eschews violence as a mode of action. If it does occur, then it poses, of course, another testing moment. Just as Lonman had at the time that the RDO said we don't want unions involved, that's a testing moment. Do you fall in with that, or do you maintain first principle and look for a way to deal with it? When you get violence, then one has to, with respect, you've got to say, well, this is the labor relations issue, and this is a violence issue. The violence issue, if there is criminal conduct, which there must be if there is violence, is not to be treated differently because it has a root in a wage issue or an industrial dispute or whatever it is. That line has to be preserved, and that is why it is necessary, with respect, to examine, for example, the appeals by Mr. Sogwana, my president at the time, comes to Lonman on the Sunday afternoon in the immediate aftermath of what has happened to Mr. Fundi and Mr. Mabalani. He has a meeting with management. He determines correctly that Lonman is not in a position to secure the situation. That is common cause. And he then starts to say to the provincial office and then to the national minister, we have to restore law and order. Now, Mr. Zakwana was taken up in one way or another in various places, and there's evidence, and he was consistent throughout. He says that this is no longer, when you have violence of this order, of this nature, then peace has to be restored before you can properly address the issues of negotiation. And he was consistent in that. And in our respectful submission, that is sound on the basis of what I'm saying. Chair, we've had a lot of cross-examination, which has, one way or another, led to some blurring of the issues. So a number of police officers have been cross-examined, for instance, on the basis that the true dispute at Lonman was a wage dispute. Well, Yes, that's the underlying dispute. Well, then you policemen shouldn't have been there, because now you are interfering with a wage dispute. And we say that those propositions and all of them along that line need to be carefully examined. If a police officer, and I'm thinking of Mr. Mpofu, my learned friend Mr. Mpofu's submissions about what had been said by the provincial commissioner, if a police officer says we are going to act there in order to break a strike, well then, from a philosophical position, that would be incorrect and unacceptable. And there can be no doubt about that. If the police officer says we are going to position sufficient forces there and take the indicated action in order to break the criminal conduct, then that is appropriate. Chair, that's a distinction that must be made. I'm going to leave the topic, if I may, of collective bargaining. I hope that I haven't spent too much time on it, but it did seem to be something.
You've given us full heads on it.
They're there.
What you've said is served to explain and highlight the main points.
Well, then, if I may just very swiftly go through a few topics relating to other aspects, and immediately drawing on the position of Lonman security. My learned friend, Mr. Bum, in the course of his submission, said, well, when you look at Lonman's deficit in terms of its security apparatus, and if you examine what happened to Mr. Fundi and Mr. Mabulani, you've got to remember that it took a decision in 2005-2006 that it would demilitarize its security apparatus. Well, that's fine. But we have very clearly, both in our cross-examination and in our written submissions, made this point, and I'll echo it because it seems to occupy fairly cardinal terrain here. Once Lonman takes that decision, disposes of all its armored vehicles, reduces its security personnel, relies on CCTV, relies on other sources of information, then there is a consequence that it has to address. And that consequence is that it has to ensure that its elimination, in effect, of any capacity to deal with large-scale events of the kind that arose, as from the morning of the 11th, if it no longer has the capacity, then it has to ensure that SABC will be there on time and in sufficient force. And it comes back to what, of course, I underlined in my cross-examination of Mr. Blow, to this notion of scenario planning, which is two words that we respectfully submit should be very close to center stage in the consideration of Lonman and what it failed to do. Scenario planning, you sit and you do the obvious. You say, well, we've got this situation. We've both we see that there's a very big mood shift on the 10th. Where is it going to go? What do we need to prepare for? We must see to it that SABC is there, because if that happens, we cannot deal with it. The 11th, the events of the 11th, one may say, well, that's on the cusp. We submit that it's over the cusp and that they should, in fact, have identified that possibility. But once we get to the 12th, Chair, for Lonman security to, at that stage, still be at odds and ends, as we said in our heads, Mr. Sinclair is putting out memoranda that talk about a revenge attack and preparation for war. Mr. Blow is blithely unaware of any information of that kind, of any prospect of that kind. He says, well, it's a Sunday. We've never had these sorts of things on a Sunday. Now, that we say is absolutely inexcusable. That failure to actually do the ordinary thing, to take stock, to evaluate, to plan, to say, if this happens again, we're in trouble, SABC. And to see to it in a concerted way that SABC is there. They didn't. they complain. They say, we made calls and nothing happened. Well, you've got to be far more deliberate in a situation such as this. And we say that that kind of deficit really led to a situation where Mr. Fundi and Mr. Mabelani died on the morning of the 12th. If I may just say one thing about the situation there in this context. You've heard that Mr. Mabelani was determined that his force of a dozen people or so would stop this march, that it would prevent the destruction of the NUM office, and we know that in retrospect was not a sustainable decision given the nature of this crowd. We know, of course, that he also didn't know about Mr. Lowe's warning, do not engage. That's another deficit. But what that underlines is this utterly unsatisfactory feature in Lonman's evidence on security, which Mr. Blow described as, well, they may be in an invidious position, the security officers. So on the one hand, they've got to defend, that's their duty, they must protect. On the other hand, we tell them, you know, if it's dangerous, well, then extract yourself. They leave people like Superintendent Mabelani and Superintendent Fundi hanging in the middle. When they get there and they see a march, they say, all right, well, that's it. We run away, and whatever they're going to burn gets burnt. It's just an impossible situation to put them in. Mr. Mabelani takes his stand. Chair, you have used the word in respect of him, courageous. We echo that with respect. It was an unsustainable decision. And also to underline what an aspect of that, because Mr. Bum referred to Mr. Masibi, that what Mr. Masibi tells us in his evidence is, as part of the disagreement that there was amongst the security officers when that line was being formed, not only the question of how do you park vehicles and so on, not only the question of, but there aren't enough of us, but also the question of there is no armored vehicle. And had there been an armored vehicle, then Mr. Fundi and Mr. Mabelani would have been able to leap into that instead of jumping into their Lavina in the hope that they could get it started and drive off. So it again, that underlines the clear understanding of the security personnel themselves. And what my learned friend, Mr. Bum, did not really address was a query from yourself, with respect, Chair, which is that the presence of armored vehicles are not necessarily there to deal with a mass situation. They're there to protect your personnel. Mr. Bum rather dismissively spoke about, well, can you imagine a situation where Mr. Sinclair is at the head of a procession of armored vehicles? It's not the point at all. It is this built-in deficit which is known. It is known to Lonman Security because they have twice motivated for armored vehicles to be obtained. It is known to Security Officer Masibi when he sees where he is that Sunday morning. And the only remedy, Chair, was to ensure that there were armored vehicles as a last resort and that they were used, or that SAPS was there. And that I've already made a submission about in relation to proper planning and proper calling in. Chair, may I turn in the last minutes that I think I have available to me? To one or two aspects relating to the events of the 10th and 11th in respect of the position of NUM. First of all, the 10th, Chair, we know that what happened was that there was intimidation began. It's documented entirely at the logs. Mr. Seteleli has dealt with it also in his statement. as we've set out in our written submissions, one can be quite certain that there were more events than those that are documented in the Lonman log. But those began as early as 4:30 that afternoon on the 10th. NUM took up the position that its members and others who wanted to go to work should be able to get to work. And they took up the position that they would perform an escort function. And we stand by that decision. We have in our heads and in our replying submissions, and we say that in a situation such as that, there is again potentially a difficult choice to be made, but there are people who want to exercise their right to go to work. They want to work, they want to earn money, they want to look after themselves and their families. And where Lonman security is not in a position to ensure safe passage, then NUM took it upon itself to do that escorting. Now, as was noted in the OB, there was a query, I think Mr. Kwadi, who said, was it Kwadi? No. Says, well, there's a bit of concern about NUM doing this because of the risk that it takes the law into its own hands, and that might give rise to conflict. And that's a concern that does come into the picture, Chair, and a holistic assessment of everything that took place must have regard to that. But on balance, we say that what NUM did was indicated, and that otherwise, you know, one says, well, you're taking the law into your own hands, but it's in a situation where you have strikers who have taken the law into their own hands and who are asserting not only their right to strike, but some entitlement to make sure that you don't exercise your right to work. That's unpalatable, and it's in that particular interface that we say it's warranted. My learned friend, Mr. Mpofu, has spoken yesterday about this quantum, as he has done from time to time, which is, he says, driving around and shooting at people and forcing them to go to work, etc., etc. We have from the start disagreed with that entirely. Even in his heads at this stage, Chair, we see no reference to evidence to that effect. And ultimately, of course, Mr. Setelele made a statement and gave evidence, and he says that in the course of that night, he went out with a quantum on several trips. As it happens, he saw no intimidation. There was only one occasion when there was a group of people who said, well, you're breaking the strike and we're going to kill you. But Mr. Setelele was the person to whom propositions of that kind had to be put, and they were not. So we ask you to disregard that. There are some hearsay suggestions in the evidence of Mr. Maboya Kulu that somebody came to the meeting on the 11th of August and spoke about shooting from the quantum, and goes so far as to say that someone was actually injured, but there's absolutely no there's no corroboration for that at all. Chair, in respect of the 11th, we have addressed the events in and around the NUM office, I hope quite comprehensively in our heads of argument. May I just say two things about it? The one is that there have been suggestions that when the NUM officials fired the shots, that was at a distance of about 50 meters, which of course is a very different picture from what in fact it was. Mr. Gegeleza has given a very close description and detailed description of it, and this confrontation actually ultimately happens right in the vicinity of the intersection between, if I may just refer to YY2, Street B and Street C, in the area of the MTN container, which is right on the corner, right next to the satellite police station. The same is said.
What was the distance then?
The-
What was the distance between the Num people and the advancing strikers?
At the
The time
time,
the shots were fired?
at the time of the shots, that would have been a matter of meters, Chair.
Meters.
Well, it's we have it there, Chair. The evidence of Mr. Gegeleza is that some of the strikers had come round. They'd gone into Street C and were proceeding into Street D. There were some NUM members there outside the NUM office, below the words WPL. Gegeleza and his small group were on the other side in Street B, and they were outside the NUM office. So that would be a matter of 10 meters, Chair.
Even if it was 10 meters, was there not time, regarding the fact that the strikers appear to be armed with pangas and spears and so on, according to the NUM evidence, was there not time for the NUM people to give a warning, to shout, say, if you come any closer, we will have to fire, and possibly to have fired a warning shot or two in the air? Was there not time to do that?
Chair, well, let me first of all address the question of whether there may not have been warning shots. Mr. Gegeleza's evidence is that he heard 3 or more shots. We also know, because it has been put by my learned friend Mr. Mpofu, and it's the evidence, it's common cause really, that it is upon the firing of the shots that the strikers turn and run away. Now, Chair, there's a logical...
The timing of shots, 2 people appear to have been injured as a result of gunshot wounds.
Well, correct, but there's a logical corollary to that, Chair. 2 people are struck by bullets. They are already running away. As a matter of logic, we submit that means that there were shots that induced them to turn and begin to run away. Now, I can't say to you that those were warning shots, because that's not something that I
I'm sorry to correct you.
can
The
say.
answer not be that what we, prima facie view obviously at the moment, but what I think prima facie we should do is to refer this whole matter, to what happened in relation to the shots and the injuries, to the provincial DPP with a recommendation that he have it fully investigated. Where the docket's already been opened, in fact, the attempted murder docket's been opened, but it would appear that the investigation stopped when the commission started. Have it fully investigated, and then consider, in the light of the information received as part of the investigation, whether there should be a prosecution.
Yes.
If the evidence indicates that there were warning shots, which is why the people were running away, then of course the other question would be why, if warning shots were fired and people were reacting to that, there were then shots fired at a dangerous level. But anyway, those are all matters that the DPP would look at, isn't it, sir? Yes. So we don't have to make a finding. We can't really make a finding on the basis of what you say. Anyway, it would be inadvisable for us to make a finding which might prejudice any future criminal case, if there was one.
Yes.
The most we can do is what I've said. Isn't that where we can leave it?
Chair, entirely. I'm in full agreement with you with respect, and perhaps I should have made it clear that the only purpose of my going into the question of whether there might have been warning shots was merely to see that is left open here.
Yes, yes,
That one shouldn't have a finding that there were not warning shots. But on the question that you raise about the fact that there are dockets and that there should be investigations, that they were suspended because of the commission, NUM has no quarrel whatsoever with that course of action. From day one, we declared ourselves to be in favor of action against anybody who had conducted himself or herself in a way that required it. So where one has, if I can just put it bluntly, one has the firing of shots. It's a complicated situation which is unfolding very quickly. One has injuries. That must be investigated. There are dockets, they must be pursued. And NUM aligns itself without reservation with that. And I may add, Chair, to that, that Mr. Mabuya Kulu also gave evidence that as he was fleeing and he had got to the Shachen workshop, he received blows from apparently a member of NUM who was part of the group that was seeking to keep him on the move. That too, Chair, that can't be called part of the defence of an office or self-defence. That too must be investigated. And again, we align ourselves fully with that course of action.
I understand that. I'd like to ask you a question about another aspect of your argument. I don't know how much time you've got left, but quite an important point that I'd like to ask you about. And that is, of course, the case that's put up by the strikers is they went unarmed. So it's argued at this stage. To the NUM office, they were to ask the NUM people nicely to take up their demand or claim for increase in emoluments and so forth. And that it was because NUM attacked them that they then took arms and went to the Kopi. That's their case. And the excuse for not handing over their arms later is they were keeping them to defend themselves against NUM. And that's a matter you've addressed in your heads. But what I want to ask you about is the factual dispute as to whether they were indeed unarmed when they approached the officers. Now, you deal with that to some extent at the end of paragraph 211 of your heads on page 75, where you quote the evidence of Mr. Gegeleza, who describes, he saw the marchers turn the corner from Street A to Street B, coming in the direction of the satellite police station in the office. They were singing songs, moving fast, running. Their mood was aggressive. And then he says he saw sticks, knobkerries, pangas, and spears amongst them. Now, what I'd like to ask you is, what was that evidence of Mr. Gegeleza challenged in any way in cross-examination? I couldn't find any passage on the matter, but have you submissions to make in that regard?
I don't recall that being challenged. This, in fact, for the greatest part, his description of what happened was not challenged. There was some cross-examination around the question of pangas, in the sense that although he had given that evidence, pangas had not been included in his statement, if I recall correctly, and there was a query raised at that level. But may I just say that Security Officer Dibakwani in ZZ3 is quite clear that what he saw were knobkerries and spears amongst them. So they were not unarmed. Those are both, of course, potentially lethal weapons.
The suggestion which they make, the statement they put up, was they needed retain their weapons to protect themselves against NUM. If NUM had attacked them, they'd gone to them unarmed. That statement, if the evidence that we're now talking about is correct, that statement of the strikers was untrue.
That is our position. What we have said in our heads of argument is that we accept that after this confrontation at the NUM office, that they armed themselves more heavily. But that's an entirely different proposition from the blunt one. And we qualify it. We say that was because they intended to revisit the NUM office, but this time there would be no retreat and there would be no surprise.
I can't remember the number. I'll have to look at the statement. Perhaps you can tell me. How many weapons did Mr. Kasim was the weapons merchant in Marikana? How many weapons did he sell? I know he sold his whole stock, but how big was his stock? Sorry?
30, Chairperson.
30, yes, thank you. So the armaments which were possessed by the strikers increased by 30, if that was the only source of additional armament.
Well, that's correct. But let me say this, that Marikana, of course, is a place where a great many people had weapons anyway. And you'll recall that Mr. Sedeleli says in his statement that there were weapons in the NUM office that morning. Usually there are none. Some came from strikers from whom they'd been taken. Others came from NUM members who, in the course of the events of the evening, had gone home to fetch them. So it wouldn't, Mr. Kasim's stock would in no way define, it went, but that would in no way define the quantity of weaponry around. Chair, what perhaps if
I don't know if you saw Mr. Wesley's sign that he held up.
I was avoiding looking at him, but I was how much? 5. I've been informed of its
Popular song when I was young called "Only 5 Minutes More." That's what that's what the song's about.
My time is now brutally short, and if I may just make one further point, Chair, related to what you've asked me, and that is, why were the strikers going there that morning? Was it this innocent expedition, or was it what we absolutely believed, and that is that they were attacking with the intention to burn it down? Now, in the course of the submissions made for AMCU by my learned friend Mr. Gotts, he spoke about this information that the strikers were going to come to the NUM office to burn it down, and he called it a rumor from an unidentified source. Now, that's simply materially incorrect, and this is the particular point I want to make. In our replying submissions, we've identified, we prepared a short, condensed version of factors that relate to the motivation that these strikers had when they came to the NUM office. The first one is that Mr. Dibekwani, on the Friday evening, so this is in the course now of NUM having demonstrated its opposition to the strike and its escort functions. He receives information that they are going to have a meeting on the following day because they are angry with NUM, because what NUM is doing is not to adhere to the embargo, the work embargo. Mr. Dibekwani gets another report the following day, and so, of course, does Mr. Motlogelwa. He also hears it, and it comes through on the system that now they're going to the NUM office. Friday evening it was they were going to go and challenge them. Now it has become they are going to burn the office. But where does this information come from? Is this an unidentified rumor? It's not. It comes from a trained Lonmin security operative who is posted there underground for the very purpose of discerning what it is that is being discussed and what it is that is being planned. And he reports that in to Lonmin Security, its command center. It becomes part of the record. Now, that is not a rumor from an undisclosed source, and incidentally, he's not unidentified. Last week, Ms. Pillay, when the question arose, informed the Commission that, in fact, we know who it is. There's a statement, we have the name. He just won't give evidence for fear of his personal safety. It's not unidentified. But when it comes, Chair, to classifying the weight of hearsay evidence, we submit that far from this being a rumor that passes from some incidental person on the scene.
I don't want to interrupt you unduly. The 5 minutes is up, but the point you're making is a point that I think you can finish off in 2 sentences, as long as the sentences aren't too long.
Yes. All right. 2 sentences. Thank you. 2 short sentences. I'm being misled by my learned
Take advice from Mr. Mpofu on short sentences. I'm not sure that his practice is necessarily the correct one. Say that in a friendly way without being critical.
This report is from a high-quality source, part of his trained function and deliberately given for the purpose of a security operation. One could hardly have a better quality hearsay statement than that. Chair, I thank you for
Several semicolons in the first sentence. Whenever. Thank you. Thank you very much.
Thank you, Chair.
I think Mr. Nkosi Thomas, you're next.
Indeed, Chairperson. Thank you, Chairperson. Honorable Commissioners, we have been allocated 45 minutes. We have no intention of using the entire 45 minutes, and we're happy to donate the remaining time to my learned friend, Mr. Semenya.
The donations have to be made to me. I accept them, and I decide whether I'm going to keep them or I'm going to have them on. But I hear the suggested destination of the donation.
Yes, perhaps all I can do is to recommend that as Chairperson considers the allocation of that time, Mr. Semenya should be given preference. Chair, we have filed brief heads. We have no intention of regurgitating, repeating that which we say in our heads, but this is what we propose to do before you this morning. We propose to deal briefly with the policy framework issues. We also propose to deal with the facts to the extent that they pertain to the former Minister of Police. And those facts would really be the facts around the political pressure thesis. And having done so, Chairperson, we will then deal with our learned friend's submissions, in particular our learned friend Mr. Mpofu's submissions, our learned friend Mr. Mugai Toby submissions, and the evidence leaders, we part ways with them on a tiny issue, and we will then deal with it. But for the most part, the evidence leaders and us are aligned on major issues. As regards, Chair, the policy framework issue, it is not controversial. Perhaps one should start there. Exhibit R before this commission being the policy that governs situations such as the situation that obtained on the 16th has been determined by the minister. He says in evidence that it is not an event, that is the implementation thereof. It's going to take a while. Certain pieces of the policy have been implemented, but he's yet to roll out some of the components thereof. He cannot, we submit, be criticized, Chairperson, for the policy not having been fully rolled out. He explained fully why that is not so. What is important is that the fact that the policy has not been fully rolled out is not the cause, as it were, of what happened on the 16th and the days prior. This we say at paragraph 15 of our heads of argument, and we rely in that regard on what Professor Gary White says. He says in that regard that it is not the policy framework that explains the disastrous operational outcome that was witnessed in the police actions at Marikana, particularly on the 16th. So to the extent, Chairperson, we concede it has not been fully rolled out. It was not because of that what occurred, Chairperson. Secondly, as far as the policy framework is concerned, Chair, there is the report that served before this commission, the NDP report. The evidence suggests that, uncontradicted, that it is now government policy. Certain portions of it have been implemented. For example, the demilitarization.
The National Commissioner seems to have a different understanding, but on behalf of the Minister, the former Minister, you concede that her understanding was incorrect, and that is government policy and is to be implemented.
Oh, I didn't follow. I beg your pardon, Chairperson.
The National Commissioner's evidence about that chapter of the National Development Plan seemed to be different. She said it was just a discussion document. She was asked whether it was going to be implemented, when, and so forth, and she gave different answers. But I'm saying, I'm putting to you that that's not your argument. Your argument on behalf of the Minister is it is government policy, and it is going to be implemented.
Yes. And certain portions of it have been implemented, i.e. the demilitarization is underway as we speak. That now takes us, Chair, to the allegations of undue influence. We've dealt with those in our heads. That debate starts from page 10 of our heads. And all that there is to be said about this, Chairperson, is that there is no evidence before this commission. Our learned friend, yes, our learned friends for the families in particular, sought to make a big issue out of the fact that the minister was called by two gentlemen, Mr. Zokwana and Mr. Ramaphosa, on the 12th. And having been so called, he conveyed the message to the operational team. They sought to interpret that as political influence. But it's impossible, it was impossible in argument of our learned friend, Mr. Mugai Toby, to get past your Kalahari example, proverbial Kalahari farmer issue. And that is precisely because there is nothing controversial, there's absolutely nothing wrong with either Mr. Joe Soap or indeed Mr. Ramaphosa calling the Minister of Police and saying, intervene because acts of criminality are taking place. The minister would have been remiss in the extreme had he, having been so informed, sat on the information, sat on his, don't want to use, not conveyed accordingly, I didn't want to use unhappy words, Chair.
Sat on his chair, perhaps.
Perhaps, thank you. So it's a better choice of. He would have been criticized. It's a question of, and I think our learned friends also on behalf of lone men used the phrase damned if you do and damned if you don't. The question really is, can it be said that the minister overstepped the line, the bright line between meddling and oversight? There is no evidence that suggests that that line has been breached. Some of our colleagues agree. In fact, perhaps I'm getting ahead of myself, but I mean, the heads have been read. I don't have to go page by page. But there is a judgment that we refer to in our heads, and the evidence leaders refer to the Glenister judgment of Constitutional Court, where the Constitutional Court makes it clear that the kind of oversight that we have, the executive exercising oversight over SABC, is part of our constitutional scheme. It's not problematic. There's nothing wrong with that. What becomes a difficulty is meddling, i.e., the minister, instead of exercising his oversight functions, delves into matters operational. There is no suggestion whatsoever before this commission that the minister sought to give operational directions to the generals. If anything, the evidence is overwhelming that the minister merely sought to validate what is happening in Marikana. I have received information that acts of criminality are underway. Is that a fact? Then he gets told, yes, it is a fact. What is happening? Are you operational guys taking care of the situation? Yes, Minister. We are, in fact, actively seized with the situation. And that's the general tenor of the numerous conversations that he had with his operational team, Chairperson. There is no evidence of the line being crossed. There's no evidence of meddling. There's no evidence before this commission that operational orders were granted at any stage whatsoever by the minister to the operational team. And we accordingly submit that the proposition that the minister exerted undue pressure on the operational team. It's only been mentioned merely for being rejected chairperson. I'm now quickly going to move to deal with my learned friend, Mr. Darlin Pofu's heads of argument and what he says.
Proposing to take the tea German roundabout now, I leave it to you to decide whether you want me to take the tea German now. You can get refreshment to strengthen you to deal with Mr. Mpofu after the tea German, or whether you want to
I'd rather confront Mr. Mpofu when I'm fresh, chairperson, after the tea adjournment.
15 minutes.
So it's an appropriate moment.
15 minutes.
May it please you.
commission resumes. Yes, Mr. Nkosi-Thomas. You were going to deal with the allegations of undue influence from pages 10 and following of your head, I think.
Indeed, Chairperson, we now propose what the submissions that we've made already sought to summarize the crux of what we say there in the written heads. We propose to deal with Mr. Mpofu's heads of the points that he makes in his written heads as regards this particular thesis. He deals with this issue from page 116 and following of his heads. At paragraph 337 of the heads, the following is stated, Chairperson, that after the end of the NMF meeting, now this would have been on the 15th in the evening, 15th of August, an extraordinary sitting of the NMF was convened to discuss the situation in Marikana, and this was chaired by the National Commissioner. He then continues to say, it was at this meeting that the decision was taken to proceed to stage 3 of the operation or the tactical phase. In the event that the anticipated negotiations would fail. Paragraph 340 says the National Commissioner was also in telephonic contact with Minister Mthethwa regarding the situation, and this is the 15th now. And what emerges from what is stated here, Chairperson, it appears to be the case that the actus reus, the conduct, the morally reprehensible conduct complained of on the part of the minister that yielded the unfortunate outcome on their thesis is this that is found here. The fact that it was decided on the 15th in the evening to execute stage 3 and 340. The minister was kept informed of that decision, 341. She informed the minister, proceeds the argument. She informed the minister that stage 3 of the operation would be implemented. This is according to the initial statement. That's something else. I'll leave that out. 342. It is respectfully submitted that the Commission must disbelieve the evidence of the National Commissioner on this point. Okay. And this Commission must proceed from the point of view that she informed the Minister of the decision to implement stage 3 of the plan. All of this is happening on the 15th. And then, having laid that foundation, our learned friends proceed to conclude at paragraph 361 of the heads that in view of their foregoing and to cut to the chase, this is what is stated there. It is, I think it must read, it is submitted. That must be a typographical error. It is submitted that a finding ought to be made, that actionable failure and so on, and that the following persons should be charged. Mr. Mthethwa is mentioned there, 361.2 as accused number 2. Of course, having had the interchange, the argument by our learned friends and the interchange with the chair and the commissioners, this recommendation properly construed should mean that a prima facie case has been established so as to warrant a referral of the matter to the NDP for further investigation. This is how perhaps it should have been couched. But the foundation of that recommendation by our learned friends is based on an extraordinary meeting of the 15th in the evening, a meeting in respect of which it is common cause the minister was not in attendance. The objective evidence before this commission demonstrates that from that time, the evening of the 15th, until the occurrence of the tragedy, the minister never spoke to either the provincial commissioner or the national commissioner. So the connection, the nexus is unclear with respect why is it that that meeting, which is the one, according to our learned friends, that decided on the implementation of stage 3, which according to our learned friends, it is stage 3 that led to the demise and the injuries sustained by the protesters. Where is the connection? There's simply none. One will look in vain at the telephone records to find a connection, because the only connection that can be there would have been, one would assume, telephonic contact, which is what he refers to at page 340. This is the one basis that this proposition really it has been mentioned simply for purposes of rejection by this commission with respect, Chair. Now, the conduct, again, in the sense of actus reus, relied upon, it seems, it's not clear, but it seems to have been the phone calls between Mr. Ramaphosa, Mr. Zokwana on the one hand, and the minister. And this actus reus is a moving target, because when one looks at the totality of the evidence, at some point the political rhetoric is the actus reus that has the causal effect. But for now, we'll just confine ourselves to this second actus reus, which occurs at paragraph 359 of our learned friend's heads. There it is stated that the unlawful activities and utterances of the two commissioners were a response to a political, or to the political pressure exerted by Mr. Ramaphosa via Minister of Mtetwa and so on, as the unlawful conduit. Now, having said this, although we've made our submissions around the absence of evidence that shows meddling, there's no such evidence. But be that as it may, our learned friends, having made this statement, then proceed elsewhere in the heads to mention the so-called, what they call game changers. Now, those game changers we submit, Chair, that properly construed, they constitute novus actus, because what is said there is that there was a revenge issue that arises. I use that as an example. But we submit that all of those so-called game changers, if the actus reus, which our learned friends are relying on, is the telephonic conversations of the 12th, then the chain of causality was broken there on their own version by the revenge issue and all of the game changers that they mention, including the meeting of the NMF, which according to their argument is the one that decided to escalate to stage 3. So, Chairperson, we submit that there is no basis whatsoever to support the recommendation made by our learned friends that a prima facie case in the first place has been made out, which should on the basis of which this commission should recommend that further investigation be conducted by the NPA as far as the minister is concerned, so as to establish his culpability, or otherwise there's simply nothing to justify such a cause. So therefore, we submit that no such recommendation should be made. It's not justified on the totality of the evidence before this commission. These submissions that we make apply with equal force to Mr. Mukaitobi's proposal, or rather recommendation, and the fact that the matter should be referred for further investigation. What remains to be dealt with is what the evidence leaders deal with in their heads, namely the closing of ranks. They deal with that at page 502 of their written submissions, and they arrive at that conclusion based on the press conference, the statement that the minister made after the fact, addressing, I think it was a parade, addressing the members of the police service, mentioning things like We appreciate a professional police service. We appreciate your effort of maintaining and upholding the rule of law, and so on. The interpretation that they seek to ascribe to the content of that address by the minister is that it amounts to a closing of ranks. There is no direct evidence, as far as the minister is concerned, to suggest that he was part of any such scheme, if indeed such scheme does exist. In that regard, we submit that it can hardly be said that the only reasonable inference that falls properly to be drawn from that address by the minister is that he was indeed participating.
I'm not sure that that's the test, though. If the test is the civil standard and not the criminal standard, then the test is not whether it's the only reasonable inference, but whether it's the more probable or plausible inference. That's the law is laid down in cases like Govan and Skidmore, other cases which have followed it in the appellate division. So I'm not sure that necessarily affects the result of your argument, but just we've got to set the correct test.
Yes.
In order to get the correct answer. So the real question you have to address is whether it is a more plausible inference than any other inference that there may be, that the minister's remarks had the effect of bringing about closing the ranks, and whether one can go further and infer from the fact that he made those remarks that the submission made by the evidence leaders is correct.
Chairperson, thanks as regards the for that helpful advice. He says advice, yes. But it does not, Chair, with respect, alter the outcome of our the conclusion that we would have applying the same test, because we say so because the minister had, first of all, he is not saying, he's not judging the conduct of what happened the previous day. That's the first thing. Secondly, it cannot be disputed that there had been acts of criminality. The only issue at that stage is that it was unclear who had committed the acts of criminality and so on. So all that he's saying is that to the extent that you conduct yourself as a professional force, not only in respect of yesterday, but ever since, we have to remember that this police service would have been dealing with all getting about Adlioti and the likes in jail and so on. So it wouldn't have been prudent for the minister on that day, simply because of what had happened yesterday, which was yet to be investigated, to start castigating and judging and being judgmental. So all that he's saying is that to the extent that you've acted professionally, and I assume that you've acted professionally as you've been doing so in the past, I thank you for that. To the extent that you've acted upholding the rule of law, yes, I'm grateful for your service to this country. He's not passing any moral judgment whatsoever. So therefore, the conclusion of the closing of ranks, Chair, doesn't follow from that address we submit. Chair, those just 1 second, please, if I may be indulged to check with my learned colleagues. Yes. Well, yeah, yes, very well. Thank you. Chairperson, those are our submissions.
Thank you, Mr. Thomas. Mr. Semenya, you're next.
Mr. Barnhouse.
Oh, sorry, I beg your pardon. Mr. Barnhouse, sorry, I had my batting order wrong.
Chairperson, honourable members, we appear on behalf of the Department of Mineral Resources. Seated next to me is my instructing attorney, the State Attorney, Mr. Matebula. We appreciate this brief opportunity to address you, and unsurprisingly almost forgotten in the process. Chairperson.
I didn't forget you. I thought you were
I shouldn't have said that. I withdraw that statement, Chairperson. Chairperson, what we thought would perhaps be the most helpful approach is to focus or highlight, perhaps is more accurately stated, highlight 7 points which were raised in the written submissions. And these are the 7 points. Firstly, the interaction between Mr. Ramaphosa and Minister Shabangu in the days shortly before the 16th of August. Secondly, the Lonman siege comment, that is the comment made during the speech on the 24th of May 2013. 3, the undue influence charge, which is really related to point 1. 4th, the requests for an adverse finding and a referral made by counsel for the injured and arrested persons. 5, the alleged failure to supervise the labor and other license conditions applicable to Lonman. And the 2 last points.
The 5th point, as I understand it, is no longer within our terms of reference.
That is
I think, the light of the deletion of paragraph 1.5, that's no longer within our terms of reference. So.
As it pleases you, Chairperson, that is precisely the point we wish to make and have made in our comment. So I would simply delete that.
What was the 6th point? That's now the 5th point?
The new 5th point is the shoot to kill comment. That was the old comment in April 2008. And finally, which would now be number 6, the alleged failure by the minister to discharge her duties. Chairperson, honourable members, the first point, and that is the exchanges between Mr. Ramaphosa and Minister Shabangu. We submit that there has been given to you a satisfactory explanation by the minister. The fact that there are some variances between their recall or versions, it would in fact, as usual, be unsurprising. It would perhaps be more questionable is that if they had exactly the same version or the same recall of what had happened. What we say also is, in any event, we say that the very substructure of this charge is in fact devoid of merit. Because, and I do not intend repeating what I'm sure you've heard several times now, it would have been surprising for the minister not to take the calls or to in some way respond to it. Even if there was influence, even assuming that what she says is wrong and that she was in fact influenced, it had no consequence. That with respect is ultimately what we respectfully submit is your interest in what was done or not done. If I may then turn to the second point, and that is the so-called siege comment. Now, there was obviously a great deal of reaction to that particular comment, and there we say again, you're dealing with a meeting of the NUM shop stewards on the 24th of May 2013. Now, what we say in our submission is that whatever she in fact intended to say or did say is again something that is so far after the event that we cannot with respect see how that should have an impact on your findings in this inquiry. I then come to the undue influence point. Now, this is of course a charge that the minister has denied. I have indicated that it is related to the first point. We would simply, as we attempted to do, point out that there is an interesting corroboration of the minister reaching an independent view in the form of her so-called Brakpan statement and also her interview that morning with Mr. Gwala. She clearly was concerned about what had been happening, and she said a criminal element, as she called it during her evidence, had crept into the mix. And there again, with respect, we simply perhaps should underscore the point. Whether or not she was influenced, she is, after all, the Minister of Mineral Resources. So anything that affects that industry, and this clearly was a major effect on the industry, as we all have seen from the events at the time and since then, it would have been irresponsible for her not to take the call or not to do something about it. And with respect, what she did is beyond reproach, we submit. That brings me to the finding that you are requested to make, and that is, we deal with it at page 13 of our tabular table of submissions. The statement made by the injured and arrested person's representative is that the involvement of the minister in any of these sordid matters should at least attract an adverse finding against her as an individual or her department, or a referral for investigation of her conduct by the Ethics Committee of Parliament and or the Public Protector. We submit there is no merit in these requests or submissions. We would ask what adverse finding and referral of what conduct. It's simply left up in the air and is no more, we submit, than Council's debating points devoid of substance. I'm left then with the two last points. The shoot to kill comment in 10 April 2008. Now, again, that was a statement made, as you may recall from the press report, which was quite frequently referred to earlier in the proceedings by Mr. Bezos. It is a comment on which people will have their views, but with respect, it was a statement made, as we understand from that press report, to beleaguered residents of certain areas who had been facing a major crime problem. And we submit the minister, in fact, refused to answer questioning on it with respect, correctly so, because it is irrelevant to the business of this commission. We then finally deal with the failure to discharge duties. Now, this is how the charge is formulated. Failed to discharge her duty to advance the lot of the historically disadvantaged South Africans. Merely by stating that proposition exposes its flaw. It is so vague. It was also, as to the best of what I could find in the record, not put to the minister in a way that she could logically deal with it. And we have asked you in our submission to, in this regard, apply the rule in Brown versus Dunn, which, of course, the Commission is very familiar with. This sort of charge should be put to a witness so that the witness can deal with it.
Before we even get there, is it covered by the terms of reference? Would that not also be a matter that has fallen away, that issue?
Yes, I respect.
Fallen away in the light of the deletion of paragraph 1.5.
With respect, so, Mr. Chairperson, that is indeed the case, in any event, as you say. May I have a moment just to confer with my attorney? Thank you, Mr. Chairman. That is all that we have to say.
Thank you, Mr. Botman. Mrs. Menya, I think it is your turn now.
It indeed is, Chair. Chair, I think in the nature of things, we're going to field a whole number of issues which have been raised against the conduct of the SAPS, and please pardon us.
I think, as far as I can see, they've all been raised so far in the debates, so it's not necessary for us to raise them again. You know what they are. Many of them are raised, I think all of them are raised in the heads of Lord and Friends. So it's not necessary for us to raise matters, unless something arises specifically, of course. But we must give you a full opportunity to deal with these issues.
Thank you, Chair. Perhaps the better place to start is this. You have been urged as a commission by various parties to make recommendations in relation to police action, which, as the argument goes, where it points to criminal wrongdoing on the part of the police, that you direct that to be further investigated and possible consideration be given by the DPP to prosecute. You have also been asked, similarly, that where there is pointers for delictual liability on the part of the minister,
Vicariously on the part of the minister. Vicarious liability on the part of the minister.
that's correct, Chair. Where there is vicarious liability on the part of the minister, that the families and injured must rest on your recommendation that you have found evidence of there being plausible civil liability of one kind or another. Now, Chair, all this argument misunderstands what a commission is. And we hope to explain it, Chair, that for my part, I'll be seriously surprised if the President receives your report, which is an advice to him, that says there are pointers of criminal wrongdoing on the part of the National Commissioner of Police. Please have this investigated. And where evidence prima facie points to culpability, then have the DPP prosecute. The President shouldn't be interested in that. And I can make the submission that it must be correct that the President knows there are instruments in this country whose primary statutory responsibility is to do that. They don't need a recommendation from you, Chair, with respect, to go and, by way of advice to the President, to go and tell the Independent Police Investigative Directorate. In fact, the nomenclature just tells you. Their function is to investigate independently where there are complaints about police culpability. So why should they wait for you, Chair, as a commission to make that recommendation? What does the President say to them? Whereas you have a statutory responsibility to do this thing, please, on the advice of the Commission of Inquiry in Marikana, I am now advising you to do that, which is your function. So it is completely unnecessary to explore that terrain. It's just outside your province. But also, Chair, your report is an advice to the President. It cannot seek to be legal advice to the families and the injured. You would not be speaking to them. If there is vicarious liability, so there is. I mean, they are capably represented by my learned colleagues, Mr. Mpofu and Mr. Nsebeza, who would tell them that if they are able to meet the elements of a delictual liability, they can sue the minister vicariously to recover whatever damages they are competent to do. But let me interrupt myself here, Chair, and say there is something even much more profound, because unless we understand what a commission does.
Before you carry on, in the terms of reference, the very end, we are enjoined where appropriate to refer any matter for prosecution, further investigation, or the convening of a separate inquiry to the appropriate law enforcement agency, government department, or regulator regarding the conduct of certain persons. You are correct in saying that we won't refer those to the President and say, you do the necessary, because for the reasons you give, it's not for the President to do the necessary. But clearly, one of the things he wants us to do, has told us to do, is if we think it's appropriate, we must do the things that I've read out. So it's therefore not correct to say that the question of possible prosecutions and so forth is not a matter that we need consider, because the terms of reference tell us we must. But in the way which is set out in that term of reference, i.e. to refer it where appropriate to the appropriate agency, which in that case would be I take it, the provincial director of public prosecution.
Yes, Chair. I thought I was careful enough to say in relation to the police. There is already a statutory institution established by law in matters of that kind.
The word used is any matter. Any matter, and any matter is wide enough to cover the conduct of the police. That's why the conduct of the police has been the subject of investigation here. Apart from the fact that the conduct of the police is also specifically dealt with in an earlier term of reference. So that's why we've, in accordance with that term of reference, we've investigated at great length the conduct of the police, and we are then asked to make certain findings, pursuant obviously to answering that term of reference. But we're also told that we must, where we consider it appropriate, refer any matter, which would include matters relating to the police, Lonman, AMCU, NUM, and the individual strikers, to the prosecution authorities, if we consider it appropriate.
I'm not resisting the proposition you put into me, Chair. I'm saying, as a matter of fact, IPT is already doing that. That's the only point I'm making. And Chair was about to say that the other significant factor that tells us what function commissions do is this. All right. You immediately look at section 84 to F, and you see those are the constitutional powers of the President to appoint a commission. Then next you realize that that happens under the Commissions Act, and there is something very, very instructive about that if you look at it. It says a commission of inquiry is to investigate matters of public interest, not to adjudicate them, to investigate them. And then one goes to the terms of reference to go and see exactly what your instruction is in terms of those terms of reference by the Commission to the Commission. It says, please investigate, not to adjudicate. And might we make this point, Chair, that if you look, for instance, at the Inquest Act, you'd see that the function of an inquest is to investigate, and if there is any finding of prima facie criminal wrongdoing, to then take the matter forward. I'm just saying at the very highest. You'd also see that it is often presided by a judicial officer of one kind or another. Even where there is conclusive evidence before an inquest, it cannot make a finding of murder, for instance. Even if it can identify who the killer is and that the death is unlawful and what have you, and there's a good reason why that is so. Why the statute curbs its area of investigation to be purely that. You do not want to end up with an inquest finding that somebody has been murdered, and in respect of the same event, a criminal court says the person has been acquitted. You would then be having two structures which are having conflicting opinions. So I caution, by the same vein, Chair, we ought to be careful in this commission not to make judicial findings. And by that I mean finding certain things to have been unlawful and finding certain things to be civilly liable and the like. There are going to be processes, I suspect, where the Constitution reposes judicial function on civil courts and criminal courts that are going to pronounce themselves one way or another on these issues. So it would seem to us that at the very highest, where the evidence is available to enable the Commission to go down that road, to say, there appears to be no reason to justify the killing of Mr. whoever. That's how high you can go, Chair. You cannot, as a commission with a duty to investigate, then go the distance of saying that so-and-so's killing was a murder or something. and if the evidence was available to say he was murdered by Joe Soap. Because by that you'd now be doing judicial function, not an investigative function. Now that leapfrogs me into the next point. And that is why it is glibly said in some of the arguments that there is an onus. And the SAPS, in the face of a killing, if it cannot justify it, as the other words used, then there must be findings and recommendations that go in the direction that we have already discussed. And then there are words to the effect that there are parties before you, which again confuses the point. There is no party before you, Chair. You are a commission of inquiry with a duty to investigate. There are even questions of what test must be applied or no test to be applied. An investigative body, Chair, should be able to say, you know what, there's a reasonable suspicion that this is true. I can't find it on the available evidence, but there are pointers to that direction. And Mr. President, this is the story. And this is what you recommend. Personally, I'd again be surprised if if the President is interested in what credibility profile Mr. X offers. Whether he's a credible witness or not a credible witness, I wouldn't think that to be particularly important to the President. But if there is a reasonable possibility that what he says in fact explains what the tragedy Marikana is and that got us into domestic shame and international condemnation is true, I think the President is interested in making sure that the policy formulations they do as government and other measures they are able to do, even legislatively, they can help South Africa avoid another Marikana. That is what he would be interested in. You cannot say in the face of that evidence which holds a reasonable suspicion to be true, to say what? No, Mr. President, I'm not going to tell you about it because it did not pass a threshold. What threshold? There are no thresholds here.
Before you carry on, I have a problem in the very beginning of this line of argument. The terms of reference say the following. The Commission shall inquire into, make findings, and report on and make recommendations concerning the following, taking into consideration the Constitution, other relevant legislation, policies and guidelines. That's at the very beginning of the terms of reference. So I think I must have misunderstood you, because I thought you said that we mustn't make findings. But if we say to can you imagine what would happen if we say to the President, thank you, Mr. President, we spent over 2 years, spent how many million rand in sitting holding investigations. The investigations are all there in the record, in the exhibits. We're not going to make any findings because we mustn't. We'll make some recommendations, and that's all. That can't be right.
Chair,
It's understood you. So perhaps you could
the fault may not
the submission in a way that I can understand.
The fault may not be yours. It might just be my inability to articulate myself as proper as I should. Of course, we're going to be discussing in the course of our submissions what factual findings can be made. Was the proper plan? Was the plan proper? Could it have been done differently? And a whole host of other things. Of course, there's going to be the submission was make the factual findings which you are entitled to make as an investigative body. Please do not do adjudicative functions. That's the difference between. That's what I had meant to convey with that submission, Chair. Perhaps let me say, Chair, that difficult as it is, but perhaps my duty as a lawyer entails that I do that. Speaking for myself personally, I would hope this process was to yield restoration. I hope it was to yield reconciliation. I would hope there would have been compensation and such similar things, because as a human being, I think it touches me closely. But as a lawyer, I must point out that unlike something like the Truth and Reconciliation Commission, which operated on a particular statute, which statute gave it powers to make reparations and to pardon if certain criteria is met in relation to the particular evidence of one or other individuals. This commission doesn't have those powers. Your powers are contained and constrained by the Commissions Act and the terms of reference. But my heart goes out to those who suffered injuries and lost their loved ones in all of this. Chair, my learned friend, Mr. Chaskelson, correctly says this to us. Please let us not forget the horror that day was. Let's not get numbed by the effluxion of time, which is 24 months or so, and we lose sight of what that horror was. Might I just put for later, looking at the police conduct, and I will hark back at what Mr. Tip was saying. Ms. Fundi has been coming here daily. Mrs. Fundi, on days that the commission sits. It's 2 years down the line, she's still in black. And I don't have the evidence, Chair, but I want to give us a somewhat a graphic account of ordinary life. I think, and I surmise that on 12 August 2012, early in the morning, Mr. Fundi wakes up as he would normally do when he goes to work and says to his wife, I'm doing this type of shift, I'm knocking off at this type of hour, and oh, by the way, that domestic chore or that other domestic chore, we will get to be able to do it next Saturday when I'm off. Kisses his wife and leaves the door. He's not signing a death warrant. He is consciously doing what you and I are entitled to do. We wake up every morning, we come to work without necessarily knowing that to be a life-threatening endeavor. And he does it because he has to fend for his family. Now he gets to work, obviously to go and do security services, which he has been doing for long men. Now, he is with his colleagues there, as is practice and habit in the past. They would do these security measures. There would be unprotected strikes. They would use the non-lethal weapons to use force if circumstances so require it. And so too was the day of 12 August 2012. But this time he gets hacked to death. Now this country, Chair, this is where I'm going. This country cannot allow to be numbed, Mr. Chaskelson warns us. We cannot be numbed by this. There are a whole number of dastardly criminal things which people do amidst us. They kill for a cell phone, they kill for that. But it's not many who get killed for going to work. You shouldn't die in a democratic country for purely going to work. They don't want anything from you. The motive is just to stop you from doing your work.
To stop you from exercising your constitutional rights, not to strike, if you consider it appropriate to do that.
And it is done in a milieu where we are told that one of the fundamental human rights is right to life. But why not that of Mr. Fundi? And I can say the same about a whole host of others that Mr. Tip has referred us to. Now, we would be, it would be a folly if, as we must, we only look at what the police do or not do. But let me try, Chair, to give us this construct. Because we are living in a constitutional democracy, the Constitution then says to all of us, the responsibility to maintain law and order is that of the police alone. There is no other institution in the country under the Constitution which has that duty. And then it says in relation to public order policing, because part of the maintenance of law and order is intended to give competing interests at times an opportunity to coexist in the same space, we will do it this way. We will have a public order policing unit within the police service. The primary function is that law and order, but is to make sure that those who want to exercise the constitutional rights of assembly are able to do that with those who want to drive to work. So it says, I'm going to have a Regulation of Gatherings Act. And I'm going to structure it in a way that makes sure that we are able to have a Section 4 meeting and allocate various responsibilities to each one of us, just so that you can give expression to your lawful conduct, which is stipulated in Section 18 of the Constitution. Now, and then says to public order policing, because you're not dealing with robbers and people in large-scale criminal activity, unless under extreme circumstances, I'm not authorizing you to discharge your duty with methods that are lethal. Because after all, your responsibility under this statute is to help those who want to express their legal right to do it and to do it safely. And if there should be disruptions, please, rule number 1, no force. Rule number 2, if it has to be there, it must be minimal force. 3, no more than is required to disperse those things. And we'll talk about Section 92D a little later. So already the law constrains the use of force in relation to the regulation of conduct like that. Now, this is the country where we want to live, all of us, where those constraints are placed on police in respect of lawful conduct. Now, then you have panga-wielding individuals. And you are told that they are on an unprotected strike. No, Chair, we are being numbed again. It is not strikers with pangas. it is something that a democratic society such as we are, a constitutional democracy such as we are, should trigger complete outrage. Can I show you, Chair, what we describe to have happened to Warrant Officer Baloyi? Lieutenant Baloyi, I'm told. Sorry, Chair. You will find that in our written submissions on page 60, paragraph 136.10. There, in his statement, Lieutenant Baloyi says that he suffered 9 stab wounds. 2 stab wounds on the head, 2 stab wounds were on his right shoulder, 2 on his left shoulder, 3 on his left hand, 1 on his stomach below the umbilical cord, and 1 on his buttocks. He describes the circumstances leading up to the injuries he sustained. More pertinently, he says that within 2 seconds of tear gas being fired, and while some of the strikers were approximately 15 meters away from where he stood outside the Nyala, some of the strikers started running towards him, and he threw a stun grenade to the oncoming strikers. He ran to the Nyala, and upon his arrival at the door of the Nyala, he realized that the strikers had caught up with him and were attacking him and other members of SABC. He ran past the Nyala with the strikers still chasing him. Whilst running, he fired rubber bullets at the strikers. He also used his shotgun to wade his way through the group of strikers while he was being stabbed from behind. He was hit on the head with something like a panga. He tripped and fell to the ground. The striker started stabbing him in the chest while he was kicking and ducking. The strikers attempted to disarm him of his shotgun. He was stabbed below the umbilical cord with an assegai and ended up surrendering the shotgun. He later discovered that his pistol and radio were also taken by the strikers. Now, these are men and women that we ask under the Constitution to come and look after our law and order. And now he can't because he has been medically boarded with post-traumatic stress disorder. Quite fitting. What country should look at this and accept it as par for the course in a constitutional democracy and point at those police officers every moment is available to say, but you're police officers after all? Would it be a convenient stage to have our lunch, Chair?
We will reassemble at 1:45.